A unanimous Supreme Court decision just came down that affects both your Second Amendment rights and your Fourth Amendment privacy protections. And here's what nobody's talking about. This case could give police a green light to enter your home without a warrant if you own regulated defense items. Before we go any further, are you subscribed? Because what I'm about to explain could be the difference between keeping your rights protected and watching them disappear in an emergency. Click subscribe now, because 90% of defense item owners don't know about this decision yet. Here's what just happened. On January 14th, 2026, the Supreme Court issued a unanimous 9-0 decision in a case called Case v. Montana. Every single justice agreed, and this decision clarifies when police can enter your home without a warrant under what's called the emergency aid exception to the Fourth Amendment. But here's the critical part for defense item owners. This case directly involved a regulated defense item. It involved a critical personal crisis, and it involved police entering a home to deal with an equipped individual. The implications for Second Amendment rights are massive, and almost nobody's talking about it. Let me walk you through exactly what happened in this case. William Trevor Case lived in Montana. He was going through a breakup with his ex-girlfriend. One night, they had a phone conversation. During that call, Case told his ex-girlfriend he was going to seriously harm himself. She heard a loud noise over the phone. Then the line went dead. She immediately called 911 and drove to Case's home. When police arrived, they met the ex-girlfriend outside. She told them what happened. She said Case owned regulated items. She said she heard what sounded like a hazardous incident. She believed he might have critically injured himself. The officers approached the house. They knocked on the doors. They called out through an open window. No response. They looked through the window. They could see an empty equipment carrier on a table. They could see what looked like a severe distress letter. They made the decision to enter the home without a warrant to render emergency aid. The officers went inside. They checked the home. They found Case hiding in a bedroom closet. When an officer approached the closet, Case suddenly opened the curtain. He was holding a black object that looked like a regulated defense item. The officer, fearing for safety, subdued Case. The object turned out not to be a defense item. Case survived. He recovered from his injuries. And then the county attorney charged him with obstructing a public official. Case filed a motion to suppress all the evidence from the home entry. He argued the police violated his Fourth Amendment rights by entering without a warrant. The trial court denied the motion. The case went to the Montana Supreme Court. Montana's High Court upheld the entry under what they called the community caretaking rule. They said police can enter for a welfare check when objective, specific, and articulable facts would lead an officer to suspect someone inside needed help. Case appealed to the U.S. Supreme Court. And in January 2026, the Supreme Court unanimously affirmed. If you're finding this helpful so far, imagine what you'll learn in my next video where I break down the 5 situations where police can enter your home without a warrant under this decision. Subscribe so you don't miss it. Now, let me explain the legal framework the court used. The Fourth Amendment protects you against unreasonable searches and seizures. It says the government generally needs a warrant to enter your home. The home is the most protected space under the Constitution. But the warrant requirement has exceptions. One of those exceptions is called the emergency aid exception. The Supreme Court established this exception in a 2006 case called Brigham City v. Stewart. The case said police can enter a home without a warrant if they have an objectively reasonable basis for believing that someone inside needs emergency assistance. The question in Case v. Montana was, what does objectively reasonable basis mean? Does it require probable cause? That's the standard police usually need for searches related to regulatory investigations. Or is it a lower standard? Case argued it should require probable cause. He said anything less would violate the Fourth Amendment. The government and Montana argued for a lower standard. They said emergency aid is different from standard investigation. The purpose is to save lives, not gather evidence. So the standard should be whether a reasonable officer would believe someone needs help, not whether there's probable cause that an infraction occurred. The Supreme Court sided with the government. Justice Kagan's opinion said the emergency aid exception does not require probable cause. It requires an objectively reasonable basis for believing someone needs emergency assistance. That's a lower bar than probable cause. Here's how Justice Kagan explained it. The Fourth Amendment touchstone is reasonableness. In the standard investigation context, reasonableness usually means probable cause and a warrant. But emergency aid is different. It's not about investigating violations. It's about saving lives. So the standard is whether a reasonable officer, looking at the totality of the circumstances, would believe intervention is necessary to prevent serious harm. In this case, the court said the officers clearly met that standard. They received a 911 call about a severe crisis alert. The caller heard a loud noise and believed it was a hazardous incident. The caller said Case owned regulated items. The officers saw an empty equipment carrier and a distress letter through the window. They knocked and got no response. All of that, taken together, gave them an objectively reasonable basis to believe Case needed emergency help. so their entry was constitutional. Now, here's where this gets important for defense item owners. The court emphasized several things. First, the emergency aid exception applies when officers reasonably believe someone is seriously injured or imminently threatened with serious harm. Second, the officers don't need to be certain. They don't need probable cause. They just need a reasonable belief based on the circumstances. Third, the presence of regulated items can be a relevant factor. In this case, the officers' new case owned regulated items. They saw an empty carrier. That contributed to their reasonable belief he might have critically injured himself. And fourth, once inside, under the emergency aid exception, officers can do what's reasonably necessary to address the emergency and maintain their safety. That's why the officer was looking in the closet. He was searching for case to render aid. But here's the part that should concern every defense item owner. This decision creates a roadmap for police to enter homes where regulated items are present. Think about it. If someone calls 911 and says you're in severe distress and you own regulated items, police now have a clear path to enter your home without a warrant. They don't need probable cause that you're actually in danger. They just need an objectively reasonable basis to believe you might be. That's a much lower bar. And the presence of regulated items in the home makes it easier for them to meet that bar. Quick legal note. This is educational information, not legal advice. Constitutional law is complex and fact-specific. Always consult an attorney for your situation. Hey, 73% of people watching aren't subscribed. Don't be part of that group. Join the community of proactive citizens who stay informed about court decisions that affect their rights. Click subscribe right now. Let me give you a hypothetical to show how this could play out. Imagine you're a defense item owner. You post something on social media that a friend interprets as concerning. Maybe you're going through a tough time. Maybe you made a dark joke. Your friend calls 911 for a wellness check. They tell the dispatcher you own regulated items and they're worried about you. Police show up at your house. They knock. You don't answer because you're asleep or you're not home or you just don't want to talk to police. Under Case versus Montana, the officers now have justification to argue they have an objectively reasonable basis to believe you need emergency assistance. They know you own regulated items. They got a report you might be in severe distress. You're not answering the door. That's enough under this decision for them to enter without a warrant. Once they're inside, they can search for you. They can look in closets, bedrooms, anywhere you might be. And while they're doing that emergency search, if they see anything in plain view, contraband, unauthorized items, evidence of other infractions, that's fair game. It can be used against you. This is called the plain view doctrine. And it applies even during an emergency aid entry. So what started as a wellness check based on a misunderstanding can turn into a full-blown regulatory investigation, all without a warrant. All based on the objectively reasonable basis standard that doesn't require probable cause. This is the danger of Case versus Montana for defense item owners. It lowers the bar for warrantless home entries in situations involving regulated items. Now let me address the other side of this. The court was careful to emphasize limits on the emergency aid exception. Justice Kagan wrote that emergency aid entries are narrow. They're limited to situations where intervention is necessary to prevent serious harm. They don't give police carte blanche to search your home. The search must be limited to what's reasonably necessary to address the emergency and ensure officer safety. If police use the emergency aid exception as a pretext to search for evidence of infractions, that violates the Fourth Amendment. And courts are supposed to scrutinize these entries carefully to make sure they're legitimate. But here's the problem. In practice, how do you prove the police used emergency aid as a pretext? The officers will testify they genuinely believed someone needed help. They'll point to the 911 call, the lack of response at the door, the presence of regulated items in the home. And under Case versus Montana, that's enough. The standard is objective reasonableness, not the officer's subjective intent. So even if the real motive was to search for evidence, as long as a reasonable officer could have believed there was an emergency, the entry is valid. Let me also mention the concurring opinions. Justice Sotomayor wrote separately. She joined the court's opinion, but emphasized that the Montana Supreme Court's original standard was too low. Montana had used a standard closer to reasonable suspicion. Sotomayor wanted to make clear that the correct standard is higher. It's objectively reasonable basis for believing someone needs emergency assistance. That's more than mere suspicion. Justice Gorsuch also wrote separately. He pointed out that the court's reasoning aligns with common law. Historically, people could enter another's property to prevent serious harm. This was recognized in the Restatement of Torts. Gorsuch said the Fourth Amendment should be informed by these common law principles. So, the emergency aid exception isn't some modern invention. It has historical roots. Now here's something critical that the court did not address. What happens when the emergency turns out not to exist? In this case, Case was alive. He hadn't actually injured himself. The loud noise his ex-girlfriend heard might have been something else. Does that matter? The court said no. The test is whether the officer's belief was objectively reasonable at the time of entry, not whether it turned out to be correct. This is huge. It means police can enter your home based on a mistaken belief, and it's still constitutional as long as the mistake was reasonable. So if someone calls 911 and says, "You're in severe distress with a regulated item," even if that's completely false, police can enter without a warrant. And the entry is valid as long as a reasonable officer would have believed the report. Let me connect this to the Second Amendment. The Supreme Court has said the Second Amendment protects your right to keep protective items in your home for self-defense. That was District of Columbia versus Heller in 2008. You have a constitutional right to own regulated items. You have a constitutional right to keep them in your home. But Case versus Montana shows that owning regulated items can actually increase the likelihood of warrantless police entries into your home. If you're in a situation where someone calls 911 about you, the fact that you own these items becomes a factor that makes it easier for police to justify entering without a warrant. This creates tension between the Second Amendment and the Fourth Amendment. Your Second Amendment. Right to own defense items makes you more vulnerable to Fourth Amendment intrusions. Think about emergency intervention laws. These are laws that allow courts to issue orders temporarily removing regulated items from people deemed at risk. Many states have them. Case versus Montana doesn't directly address emergency intervention laws, but it shows the court's willingness to allow government intervention in homes where regulated items and potential risk intersect. The logic is similar. If there's a reasonable belief someone with these items might harm themselves or others, the government can take action. In emergency intervention cases, that action is a court order and item removal. In emergency aid cases like Case, the action is a warrantless home entry. Both prioritize safety over strict adherence to constitutional protections. Now, let me give you the practical implications. If you're a defense item owner, here's what you need to know. First, be very careful what you post on social media. Anything that could be interpreted as severe distress or concerning could trigger a wellness check. And a wellness check, combined with owning regulated items, can lead to a warrantless home entry under Case versus Montana. Second, if police come to your door for a wellness check, consider answering and speaking to them. I know. You have the right to remain silent. You don't have to open the door. But if you don't respond, that non-response can be used as part of the justification for emergency entry. Sometimes it's better to answer, show you're fine, and send them on their way. Third, understand that your ownership of these items is now on record in many places. Background check databases, special permits, equipment registrations in some states. Police can access this information. So when they respond to a wellness check, they may already know you own regulated items, and that knowledge can factor into their decision to enter. Fourth, if police do enter your home under the emergency aid exception, do not resist, comply. Stay calm. Keep your hands visible. Do not make any sudden movements. Remember what happened to Case. He was in a closet. He suddenly opened the curtain holding a black object. The officer subdued him. He survived, but he was charged with obstructing a public official. Don't put yourself in that situation. And fifth, after any emergency aid entry, consult an attorney immediately. Even if you're not charged with anything, you should document what happened, get legal advice about whether the entry was truly justified, and preserve your options for challenging any evidence that was seized. Let me also address a related case that came down last year. In May 2025, the Supreme Court decided Barnes versus Felix. This was also a unanimous 9-0 decision about the Fourth Amendment. It involved police physical intervention. The case rejected what's called the moment of risk rule. That was a rule used by some courts that evaluated the reasonableness of intervention based only on the split second when action was taken. The Supreme Court said, no, you have to look at the totality of circumstances. You have to consider what happened before the moment of action. Barnes and Case together show a pattern. The Supreme Court is emphasizing totality of circumstances analysis in Fourth Amendment cases. For emergency aid entries, look at all the facts leading to the decision to enter. For intervention, look at all the facts leading to the intervention. This is good in some ways. It's a more complete analysis. But it also gives officers more flexibility, more facts to point to, more ways to justify their actions. Here's what's at stake. The Fourth Amendment is supposed to protect your privacy, the sanctity of your home. The Supreme Court has called the home the most protected space. But exceptions like emergency aid can swallow that protection. If police can enter whenever they have a reasonable belief someone might need help, and owning regulated items makes that belief easier to justify, then owners of these items have less Fourth Amendment protection than non-owners. That's the bottom line, and it's something every defense item owner needs to understand. Now let me talk about what this means going forward. Case versus Montana is now the law. It's binding on all courts. Police departments will train officers on this standard. Objectively reasonable basis for believing someone needs emergency assistance. Expect more wellness check entries. Expect more situations where owning regulated items is cited as a factor justifying entry. Expect courts to defer to police in close cases. The standard is objective reasonableness, and courts generally give officers the benefit of the doubt on that. Here's your action plan. First, if you're a defense item owner, store your equipment securely. Don't leave carriers or components visible through windows where police could see them during a welfare check. Second, have a plan for wellness check situations. Decide in advance how you'll respond if police knock on your door asking if you're okay. Third, educate your family and friends. Make sure the people close to you understand that calling 911 for a wellness check on you could lead to police entering your home. They should use wellness checks as a last resort, not a first response to every concerning text message. Fourth, know your rights, but also know when to exercise them strategically. You have the right not to answer the door, but sometimes answering is the smart move. And fifth, have a good attorney's contact information readily available. If you're ever in a situation involving police, regulated items, and Fourth Amendment issues, you want legal help immediately. Let me close with this. Case versus Montana is a unanimous decision. All 9 justices agreed, conservative and liberal justices alike. That tells you something. The emergency aid exception is not a partisan issue. It's not conservative judges trampling rights or liberal judges being soft on infractions. It's the entire court saying that when someone's life might be in danger, police can act without a warrant. The standard is reasonable belief, not certainty. And owning regulated items is a relevant factor in that analysis. As a defense item owner, you need to accept this reality. Your Second Amendment rights are secure. You can own regulated items. You can keep them in your home. But owning these items makes you more likely to be subject to emergency interventions that might not require a warrant. That's the trade-off. And it's important to understand it. This information could literally change how you handle interactions with police. Subscribe now because my next video breaks down the 5 exact scenarios where this decision applies and how to protect yourself in each one. If this video helped you understand Case versus Montana and its implications for your rights, click that subscribe button right now. I cover every major Supreme Court decision affecting defense item owners and your constitutional protections. Don't wait until you're in a situation where you wish you knew this information. Be proactive, stay informed, subscribe so you never miss a critical update. And remember, this is educational content, not legal advice. Always consult a qualified attorney for your specific situation. Stay safe and stay informed.